Appearance in this matter is appearance in this matter is as before, and for the prosecution team as before. But for the local people have been joined by I know the defense team is also as before set for today. I've been informed that also the assessors also and all the five accused persons. One appeared from the Zira Women Prison as well. Hello, we are ready to continue with the presentation. Let's witness.
We are ready to proceed, my God.
Mr. Morgan, when we closed on Wednesday, there was an objection. The ruling is objection about the questions put into section. The gist of the objection was that during cross-examination, DPW2 was asked questions about his retirement, his appraisal, and why he was still occupying physical office space at a government institution even after his retirement. It should be noted that during his examination in chief, Dr. Jivois testified that he retired from government service in December 2020. The defense cited sections 145, 147, 2B and C, 148, 149, and 150 of the Evidence Act in support of their assertion that the questions the prosecution was putting to the witness were insulting, indecent, and scandalous, and aimed at injuring the person of the witness. The defense, in particular, questioned the relevance of the questions to the evidence of the witness. Section 145 of the Evidence Act provides that when a witness is cross-examined, he or she may, in addition to the questions hearing before referred to, be asked any questions which tend to test his or her veracity, discover who he or she is and what is his or her position in life, or questions to shake his or her credibility by injuring his or her character, although the answer to those questions might tend directly or indirectly to discriminate him or her, or might tend directly or indirectly to expose him or her to penalty or forfeiture. Section 147 provides that court will decide when questions shall be asked and when the witness shall be compelled to answer. That is section 147(1). Section 147(2) provides for when court shall use its discretion to disallow certain questions, and these are instances where such questions are improper if the imputation which they convey relates to matters so remote in time or of such a character that the truth of the imputation would not affect or would affect in a slight degree the opinion of the court as to the credibility of the witness on the matter to which he or she testified, or such questions are improper if there is a great disproportion between the importance of the imputation made against the witness's character and the importance of his or her evidence. Section 150 of the Evidence Act prohibits indecent and scandalous questions, while Section 151 of the Evidence Act prohibits questions intended to insult or annoy. 12th edition of the Black's Law Dictionary defines scandalous as grossly disgraceful and disreputable, inducing condemnation or reprobation by reason of flouting minimal standards of decency and propriety. To annoy simply means to irritate, bother, or disrupt someone's peace of mind and make them unhappy. Determination of the objection. Court has looked at the following. DW2 testified that he is a pro bono lecturer in Makerere University, Department of Pathology, having retired from civil service in December 2023, and that he sits at B27, Department of Pathology, College of Health Sciences, Makerere University. In cross-examination, as provided by Section 145 of the Evidence Act, questions can be put to the witness to test his veracity, discover who he is, and also check his credibility. However, as provided in Section 147(1), court will decide when questions shall be asked and when the witness shall be compelled to answer. Section 147(2), which has already been referenced above, offers guidance to court in determining when questions shall be asked. Court is required to make a call on whether a question impacts on the witness's credibility and his character in relation to his evidence. Considering the above provisions of the law, it is the ruling of this court that in all questions put to DW2 in cross-examination, the prosecution is required to demonstrate that there is a nexus between the importance of the imputation made against the witness's character by the question and the importance of his evidence. That will help guide the court in determining whether the question falls under any of the provisions under Section 147.
Most of that, my lord. So, good morning, Doctor.
Good morning, Council.
Just testing your microphone to see that it is working well. Doctor, I believe you are aware that you are still bound by the oath you took last Wednesday.
That's right, my lord.
And just to set the record clear from our viewpoint, by reason of prosecution exhibit 129, it may, I use mine, use for court, 129. We can save on the time. It's the same as mine. 129,
During the next court,
So 129 is the request letter from KAA. From your testimony, you received the postmortem, the sole document supplied to you, which is the postmortem report in that exhibit on the 6th June 2024.
That's right, my lord.
And again, to refresh your memory, let me have it, please. To refresh your memory, you remember checking your phone to confirm the date when you received the additional requested information, including the photographs. That is on the 9th October 2025. I'm not asking counsel, my lord. I'm asking a witness. He can't object.
Yes, what
The objection, my lord, is that what the witness said he received in October 2025 was the soft copy pictures, not the additional documents. Now, my colleague is saying the witness testified that he received all the other documents in October 2025.
you said on the phone.
On the phone, what he received, my lord, what? That's what the witness said. The soft copy pictures, not all the additional documents and exposures. So that's, my lord, the record I wanted. Factual. The witness never said that he received all the additional documents on the 25th of October 2025. What he received and what he said, what he received in October 2025 were the soft copy pictures and they are on his phone. But the additional documents, he had received them earlier after his first opening. That's what he said.
My lord, we can review the record because what I have, this particular section he mentioned after, if we have to go by the letter of instruction after it was tendered in, and then he indicated that he retired in 2023. And when you move further, he said, I verbally asked for you to confirm, Mr. Katanga, disclosures from the DPP and the color photographs. 2 box files were delivered to me by Mr. Katanga and the soft copies were sent on my phone. That's what I said. On the same.
Okay, my lord, you may guide us on the record. But I shall also request court that, my lord, the witness be left answer without being prompted assistance. The witness can always say that is true, that is not true. That's why he took oath.
We have no part correcting the record. No.
When I asked Mr. Karanga for additional information, verbally, I asked for the following. A, disclosure, in this case B, colored post-mortem pictures. Right? The additional information I asked for was delivered to me in 2 box files, and soft copies of the post-mortem pictures were sent to me on my phone. The post-mortem pictures were sent to me on my phone on 9th October 2020. When I was first instructed, I think that an additional information required, that I needed additional information from my. So on 9th, there was soft copy. The post-mortem sent to the 9th.
My Lord, may I just request that court continues downwards on that trail so that we don't.
Continue with the.
Yes, my Lord. There are follow-up questions.
When I was first instructed, I deemed that additional information was relevant for my profession. The witness is given his first report. I nonetheless went on to form an opinion even without the additional information I considered relevant. Part of
That is the point, my Lord. So, Dr. Mzua, you are the witness here, and it is okay for you to clarify, including if you wish or have reason to change from your earlier position.
Now,
Did you?
what are we recording now?
No,
After that
I'm asking a question now.
Yeah, my lord.
I've not asked you any
okay.
questions.
Oh, okay.
So you first received these photographs of the deceased on the 9th October 2025. Is that correct?
That's correct, my lord.
So I would be correct to say that by the time you are generating your report, which is prosecution exhibit 28, your first report dated 3rd July 2024, you did not have the photographs.
No, my lord, I didn't have them.
Okay. Now, on this question of you being a head of, did you say head of City Mortuary or Mulago Mortuary?
I said City Mortuary.
City Mortuary is different from Mulago Mortuary, correct?
Correct, my lord.
Mulago Mortuary is managed by Mulago National Referral Hospital, correct?
Correct, my lord.
And the City Mortuary is managed by the Kampala Urban Authority, KCCA, correct?
Correct, my lord.
So it is correct to say that these two entities, though all located in Mulago, they are run under distinct managements, correct?
Correct, my lord.
But if I'm faster, I could be always advised. You have never worked for the KCCA or the Uganda police, have you?
No, my lord.
Who appointed you to head City Mortuary?
The Department of Pathology, my lord.
Department doesn't appoint, individuals appoint. Mr. Kabega, allow me to cross-examine.
Yes, but my lord, the witness should be allowed to give an
I will,
answer.
my lord, I'm
Then
not
if it
gagging
is
the
not-
witness. I am the one asking.
Yes.
Mr. Kabega cannot determine how I ask, my lord. I am not gagging. I am just guiding the witness to precisely answer to my question. So when he says
I believe that once counsel puts the question, even if he doesn't want the answer being given, he should let the answer to be on record. Then he can rephrase and put another question, but not to stop him from giving his answer.
I know I'm actually surprised that Mr. Kabega is now agreeing to what we were telling him to do. You know? No way. Yeah, let me ask him. Please humbly allow us to cross-examine. Please, doctor, if you feel that my questions are unclear or I am being unfair to you in any way, please raise it to the court. Okay?
That's right.
Raise it to the court.
Yeah.
We have full confidence that you carried your abilities to this court. Okay? So the question is, who appointed you? And I'm referring to an individual officer in whichever capacity that signed your appointment letter.
Yeah. My lord.
You can explain that
Yeah.
to him so that he can see.
My lord, it would be prudent for me to explain.
Mr. Onzibua, who?
No?
The question is clear. Who? Do you know who appointed you?
Mr. Morgan, you want the witness to answer exactly who appointed you?
My lord, that is the question. I'm not asking for explanations.
Doctor, perhaps you can state that
Yeah.
you were not appointed by an individual.
Maybe.
That's right. I was not appointed by an individual, but voted by the pathologists.
I'm going now to ask you to clarify whether you have any instrument appointing you to head that government facility called City Mortuary. Do you?
We have never had instruments.
Please speak for yourself.
I'm
Others do.
Yes, we don't have instruments. In my experience there in the Department of Pathology, we would just ask somebody to head.
So we don't have instruments appointing anyone to head.
No, we don't have instruments. We just request somebody to head.
Pathologists would among themselves.
That's right, my lord. That's right.
So
my
who
lord.
chaired that meeting where you were?
Yeah.
Was it in a meeting? Was it in a conference?
That's right.
Who chaired it?
Late Professor Bimenya, Gabriel Bimenya.
When?
I don't have the exact dates in my mind.
Okay. Do you have the year in mind?
Around 2018. 20,
do you know the year or you don't know?
2008.
208.
Yeah.
And you were, according to what you are telling me, for how long did you act as head? Did you head?
Yeah, that's right. I headed from around 2008 to about 2013.
Are you familiar with somebody called Dr. Barunji?
That's right, my lord.
Did you work with him?
That's right, my lord.
Where did you work with him?
I worked with him in the Department of Pathology, Makerere University.
Dr. Barunji was head of City Mortuary from 1980 up to the year 2011. Is that a fact in your knowledge?
No, it's not a fact.
Just one.
1980, 2011. Dr. Nsua, do you know who headed City Mortuary between that period, 1980 and 2011?
Yes, I do.
Who headed the City Mortuary?
Dr. Nsereko Mukasa, from whom I took over.
Are you familiar with a doctor called Moses Byaruhanga?
That's right, I know him.
He has been the head of the City Mortuary from 2011 to date.
That's not right, my lord.
What is not right is that fact.
My lord, council is confusing Director of Medical Services of Uganda Police with a person heading the city mortuary.
Dr. Nzvua, who is heading the City Mortuary today?
Today, I don't know.
When did you last know the head?
No, we need to record.
We need to write. Okay, I will slow down.
Yes.
When did you last know the head of the City Mortuary?
My lord, when I left,
Okay, so by 2023, who was heading it?
by 2023, I said, that's when I left.
Yes.
There
so
were radical changes in that mortuary.
my question, please be clear. Mr. Yaruhanga, we have Mr. Dr. Nzvua, we have about several questions for
That's
you. So
all right.
please,
That's okay.
you will do this court a favor by answering directly so that we move.
Okay.
You say you last knew the head of the City Mortuary when you left. And this court has information you left in December 2023, right? So by that time, who was heading it?
My lord,
Do you know or you don't know?
I retired in 2023.
Yes.
That does not mean that I know what was going on in the city mortuary after 2013.
So since did you last know the head of the City Mortuary? You know that is the question where I came from.
I said, my lord,
When
I
did you
don't
last
know. I knew myself in 2013 when I was
So
the head.
So from yourself, you know no other head of the City Mortuary. I want to leave this.
That's right.
So I will be correct to say that if you ever headed this place at all, my instructions are otherwise, but you never handed over to any officer from what you are telling God.
No, I didn't hand over to
You
any.
just marched away.
I didn't march away.
Okay.
We were chased away.
So will I be correct to say that you don't know the operations of the city mortuary since 20? Which year were you chased away?
2013.
2013. Will I be correct to say that you don't know how that place operates since 2013?
No, my lord.
You have no idea who works there and how they work.
My
Do
lord,
you?
I don't have any formal information to that effect.
So is the answer that since 2013 when you were just away, you don't have any information?
That's right.
As to who works there and how they work.
Yeah, I don't have any formal information.
I'm not going to ask you for rumors. So I will restrict you to what is formally in your knowledge. So when you said this place has endemic problems, and all the rest that you characterized the workings of this mortuary, you are referring to the period when you worked there.
I am actually referring to the period after I left there. Not only me, but the senior pathologists.
Talk about yourself. You are the witness in court.
That's right, but I know my colleagues were also chased.
You were chased from the city mortuary because you were among the group that was not formally established there. You were passing out and you were there without any formal instructions. That is why you were chased out of that place.
That's not right, my lord.
Dr. Nzvoa, do you hold any formal instructions? Do you have any formal instructions that placed you or assigned you to do any kind of work at that government facility?
That's right. Yes, I do.
Which one do you have?
My appointment letter as a pathologist.
No. I'm referring to assignment of duties at the city mortuary. Please, kindly, doctor.
Yes, I did at that time.
Which one did you have?
The timetable that was produced by the Department of Pathology.
So other than what you refer to as timetable, you don't have any other form of posting instructions to that facility, government facility?
No, none of us had. Me and others. That was the practice.
Dr. Nzvoa, I will still, through court, kindly request you to speak about yourself and don't blackmail your colleagues. Some of them have a name to protect. Concentrate on your issues. I don't want to ask you about other people. I want to ask about you before this court.
My lord, I want to tell the court the reality.
My lord, may he be advised to tell this court the reality about him, not other people.
Yeah.
Objection, my lord. I think my colleague can only ask questions. The witness is at liberty to answer questions, including others. But you can't limit himself and say your answers should only limit to you. He wasn't working in the forest. He was working with others. So I think my lord,
we're asking the witness about him and what he can verify. The others are not here.
my lord,
Okay.
Thank you, my lord. So, my lord, my colleague can determine questions to a witness. He cannot determine the answers, even when he doesn't like those answers. When he asked Dr. Konsiru and said, how are you working in Mulabu? And he says, that's how I used to work with Dr. So and so and Dr. So. You can say, no, don't mention those doctors. And at the same time, ask him about other doctors, Garugara, Murungi, and everybody. You can determine your questions, my lord. You cannot determine the answers the witness gives.
But in this instance, Mr. We're asking him about his posting instructions.
Yeah.
Yes,
Let him talk about his posting instructions. When the question requires him to talk about others, that is how the question.
Yeah.
Yes. Asked him, do you
Thank
know
you, my
Dr.
lord.
Barunji? Do you know Dr. Biaranga? On this one, let him talk about his posting instructions.
Yes, you see, my lord, what I am avoiding is for the witness to be given a tunnel within which to walk. You can't say, don't say this, but say this. Then why are you asking questions? Let him say what he wants to say.
Mr. Tuevas, the witness will answer that question on his posting instructions.
Yeah.
Because he wasn't working in isolation.
But they asked him, do you have posting
Yeah.
instructions? It is him who is giving evidence, not the other.
Thank you, my lord.
Court will note that the witness stated that
Yeah, yeah.
they do not have posting. They, him, that
Yeah,
he
yeah.
does not have any posting instructions to the sitting object.
And my lord, it is relevant when you ask me whether I have a certificate of P7, and I tell you when I started in 1960s, P7 never used to issue certificates to all of us. So it's not only me who doesn't have a P7 certificate from 1960s. So it's relevant.
Please be seated.
Dr. Nzvoa, we shall now move to something else. As a forensic pathologist, are you aware about the rule on sub judice? That's something new to you?
I am not a lawyer.
That's why I'm careful to ask you as a forensic pathologist.
I will need guidance, my lord.
My question is, do you know or you don't know? I don't know what guidance you want court to give you. My lord, may I request that he states whether he knows or not? Then I will proceed to that enlightenment. My question is, I kindly listen to how the words come from my mouth. They are on purpose. Okay. My question is, as a forensic pathologist, do you know about the rule on sub judice?
I do not know, my lord.
Okay. Sub judice, this rule means that when a matter is still pending determination in court, it should not be a subject of public debate. Are you hearing this for the first time?
I understand this now
You,
from
you
you.
now understand it.
From you, yes.
Are you understanding it today, or this is something that has been in your knowledge as a senior pathologist, senior consultant?
Yeah. I have always known.
Okay. Doctor, confirm that telephone number 0772 41 40 40 is your personal telephone number.
That's right, my lord.
I want you to confirm that you are a member of a media platform called Pathologists Uganda. Are you?
That's right, my lord.
At about 7:16 p.m. on Wednesday when you left this court, you posted your third opinion, what you called the third opinion, which is the PowerPoint presentation on that group, correct?
That's right, my lord.
My lord, 7:16 p.m. I want to save time and give you an extract of what you posted. Can you go to the second page where you see your number?
That's right, my lord.
Confirm the time you posted it.
7:16 p.m., my lord.
What caption did you put to your PowerPoint presentation before this court? Read it
This,
to court.
yeah, this was the presentation in court today.
What else did you say?
A prudent doctor knows when to consult and when to refer.
You confirm that that is what you posted.
That's right.
Please give it to us. I pray to have it in as an exhibit.
My lord, we object to the tendering of this document. And the rules of tendering electronic evidence should clearly apply. While the witness has confirmed that that is his phone number, the person who took this picture should be here. The phone should be here. We examine it because of the possibility to insert. We will not take a screenshot of the message I sent to you and pass it on to a lawyer, and then the lawyer brings it to court the following morning just because I sent you a hi. The person who did it should come in. The phone should be before court. We should be able to cross-examine them. It's on a professional court. They were discussing the messages I see. They were discussing his day in court and advising each other as doctors, as pathologists. Because it follows by saying, I agree, there seems to be is only allowed in Uganda, that's how it continues. So my lord, whoever those other messages, when you pick it in isolation, you don't get the entire conversation is very good. Actually, we would be happy if the doctor comes. We would be happy to have it because it seems to be a very interesting discussion between these pathologists. Very nice. But my lord, the rules of tendering electronic evidence should apply to this document. This witness is one of the best witnesses to tender it here. It's not the author. There seems to be about 10 messages on these pages. There are 10 messages. Dr. Ozikua only has one. All the others are by other doctors. I don't know, you read section 8.2 of the Electronic Transactions Act. It says a person seeking to introduce a data message or an electronic record in legal proceedings has the burden of proving its authenticity by evidence capable of supporting a finding that the electronic record is what the person claims to be it.
Just a moment.
For it
Seeking to introduce a data message to an electronic
or an electronic record in legal proceedings has the burden of proving its authenticity. So we don't know whether this was printed from my colleague Mwakanya's phone or not. This authenticity by evidence, so you prove by evidence, capable of supporting a finding that the electronic record is what the person claims it to be. So we will need evidence to prove that this is what my colleague Mr. Mwakanya claims it to be. We can't just have screenshots, my lord. So we can't even know, my lord, and that's what is important. Whether the person who passed on this one to him is on the group, we would be happy. He's on that particular group of pathologists, Uganda. If we get the person who passed on the message with his phone and we have him, then that's my lord very good. Because I like the discussion. It's very professional. It is informative. It tells us that there are only 3 people allowed to do autopsies in Uganda, only 3. But now we don't know. We don't know whether it's by a hacker. Some hacker could have hacked into the pathologist group and inserted some messages. We don't know. But fortunately, the witness has accepted that when he left, he shared his finding with his colleagues in a professional group. Just like we could share submissions in a lawyer's group. You can't use them against me. So when he has gone over the hurdle of that section, then my lord, we can consent to it, and then we even re-examine our witness on it. You must first go through the hurdle. My lord, by the way, it's also a violation of the Computer Misuse Act. It's unauthorized access by what my colleague is trying to do. It's unauthorized access of a WhatsApp group of pathologists by a lawyer in the DPP's office. We seem to be witnessing a crime being committed in the court now. Clearly, I don't know who will charge him because he's the one charging people. But my lord, we seem to have a crime. We are in the middle of a crime scene now. My lord, even 7 is informative. Section 7 of the Electronic Transactions Act. It is headed authenticity of data messages. Authenticity of data messages. Sarongwa has A and 1, where a law requires information to be presented in an original form. The requirement is fulfilled by the data message if A, the integrity of the information from the time when it was first generated in its final form as a data message or otherwise has been passed assessment in terms of subscription to, and that the information is capable of being displayed or produced to the person to whom it is to be presented. And two, for the presumption of section 2, the authenticity of the data message shall be assessed by considering whether the information has remained capable or unaltered, and then B, in light of which the information was generated. In light of the purpose for which the information was generated. That is B. In light of the purpose. The purpose why Dr. Ezuru generated this and sent it to his first what? WhatsApp group of pathologists. What was the purpose? Much right.
My Lord, we shall restrict our reply to only the legal issues, not the issues of evidence that appear to come out from DAPA. My Lord, what is being sought to be tendered is a document, not an electronic message. Once a message is printed and reduced into a document, it ceases to be electronic, becomes a document. It ceases to be a data message, my Lord, I beg your pardon. It ceases to be a data message and it becomes a document. And so the rules then govern, the rules that govern the tendering of that exhibit cannot be the Electronic Transactions Act, but rather Evidence Act. So with due respect, the section 7 and 8 being quoted by Learned Counsel are inapplicable. My Lord, under the Electronic Transactions Act, Section 2, which is the interpretation section, defines a data message to mean data generated, sent, received, or stored by a computer. And may include voice, where the voice is used in an automated transaction, and stored records. My Lord, we are not seeking to tender a data message, either voice or a video, or a message still stored in a computer. We are seeking to tender a document in its physical form. My lord, it should be noted that all documents are first generated through electronic devices, which are otherwise called computers. But once a document is printed out, then it ceases to be electronic. It becomes a document. Section 2 of the Evidence Act specifically to subsection 3, my lord, which defines documentary evidence. Documentary evidence, my lord, means all documents, explicitly, my lord, all documents produced for the inspection of the court. The law doesn't, my lord, distinguish the manner or process of generating the document. That all documents, without reference to the process, how they were generated. So in this case, my lord, the witness has been explicit. He has identified the document. He has acknowledged his telephone number. He has also confirmed that what it represents is what he posted on that particular platform. He has not denied or cast any doubt either regarding what he posted or the accompanying captions. He has not even insinuated, as counsel seems to submit, that anything was inserted or that anything is incorrect. That extent, my lord, and this being cross-examination, the document should be accepted on record. And in this case, my lord, not necessarily to prove the content per se. It's not about content, but proof of the fact that the witness posted the material on a particular platform. It can only be him, my lord, to confirm or dispute. And he cannot confirm, and there exists a justifiable reason to reject admitting it on record. So pray.
My lord, just a brief rejoinder.
My lord, he has no right to rejoinder. The application was mine. He objected. I rejoined.
He rejoined, but
My
with
lord,
leave
can I
of
have
court.
the leave of court? Just 1 minute. My lord, my learned colleague started by saying he intends to tender a document, this, and not an electronic message. said, I intend to tender a document, not an electronic. And he went to the definition section of the ETA, the Electronic Transactions Act. He says he intends to tender a document, not an electronic message. That was his opening statement. Then he went section 2 and read the definition, that is the definition section I wrote. He read the definition of data message. My lord, our objection is on the definition on the electronic record. We contend that this is an electronic record. And my lord, the electronic record is defined in that very section. So you read one definition and left the other. My lord, section 2 defines electronic record system as following. Electronic records. And let me, electronic record. Sorry, electronic record. As this, my lord, and this is the definition section. Electronic record.
My lord, with your indulgence, I thought that if our colleague wants to rejoin, he can only rejoin on what we have submitted. He's introducing new matters.
This is the definition section 2, which is the amount section 2. Yeah, it's as if, my lord, I'm just reading for you the definition. No, the Transactions Act, my lord,
I never traversed the systems, electronic systems, my lord.
Electronic record, not system, my lord.
I never read the electronic. Yes, I only restricted myself to electronic data, not systems, not record.
I said, my lord, sorry, not systems.
Where the voice is used in an automated transaction and stored.
And my lord, I'm within that same section 2.
And you're talking about electronic
record. My lord, I'm saying our objection was on electronic record, not electronic message. And I am going to the definition section because he read one part and then to go to the other. And the electronic record in that definition section is defined. It means data which is recorded or stored on any medium in or by a computer system or other similar device that can be read or perceived by a person or a computer system or other similar device, and includes, I wrote underline, display, printout, or other output of that data. The printout. That is the definition of the electronic record in that same section. It includes printout. It means data which is recorded or stored on any medium in or by a computer system or other similar device that can be read or perceived by a person or a computer system or similar device, and includes a display, printout, or other output of that data. Output of that data. Whichever way you output that data, computer record. And then section 6, 8 tells you, even 8.6 and 8.2, 8.6 tells you how you can how it can be done. 8.6, my lord, says you must follow the procedure. 8.6 tells you what procedure to follow if you want to deal with that electronic record.
My lord, on the new matter that he has just raised, we seek for your indulgence because he is introducing a new matter and in a way that is misleading. My lord, may we just be allowed one sentence? If this court was to go by his interpretation, then no document would ever be tendered as a document. Because, my lord, all documents, books, newspapers, mention it, they are originated through a computer. So if we were to go by that interpretation, my lord, all documents would be regarded as electronic, as electronic data or electronic record because they were printed through a computer system. That would be misleading. And that's all that we have to say.
Mr. Morgan, are you able to move to another matter?
Yes, my lord.
Now we'll come to this
Yes.
after the break.
No problem.
Because I'll need to go through all the different provisions.
Absolutely.
And make a decision.
Absolutely.
So we start over this particular
The
matter
ruling,
and move
yes.
on to.
That's okay, my lord. Oh, okay.
Thank you. Omulungu obujulizi ekiro kyaleero kino tugambira tekimanya nti ali hansi y'okulwanira okuyakoze ekiro kya kasatu abaye hano kandi akakora ekyandiiko kye ye kyabandize omwezi gw'omukaaga omwaka gwa 2024 kandi abwirewo nakaba atakatungire ebisisani ebyahereze iwe kasimu ebiro okwezi 9 kw'ekumi omwaka gwa 2025. Ekyandiika kyakozere biro okwezi 3 ebisale bino akaba atakabitungire kandi akaba mukulu weryaburo ly'emitumbi etawuni enkotene ya Kampala okumarra eri ekwawukana hali eryaburo lya Mulago iraro lya Mulago Efoto kandi bino byona birolerwa obusobozi obukwawukana baitu kandi nti bitegereze nti bibyona mu kicweka kimu kyonka ababikuura nibawukana n'obusobozi obubitwara okwawukana kandi takakorahoga orubuga runo rwa Kampala nobwakubaire ekitongole ekya poliisi wenka omuntu ata omulimu gwa muhairo gwakora ogukaba nakora mu kicweka kino gutamuheebwe omuntu baitu akakomebwa bagenzi b'abandi nk'okubakaba nibakora mu kicweka kino kandi kitegeezebwa nti tibaina obusobozi tibaina rundi ekukwoleka nti hariho obusobozi obubaheereza emirimu baitu bakoma bukomwa katugambe nk'okwikaara omu rukurato kandi bakaikara mu rukurato mwena badaktari abandi ntibakora mu kicweka kino olwabaire nirukurirwa omukuru Daktari Bimenya omwaka gwa 2008 kandi bamuha obusobozi okukura ekicweka kino okuruga omwaka gwa 2008 kwika omwaka gwa 2013. Abadaktari abamu abaizire nibagambwaho akubamanya agamba nka Dr. Bironge ayakolire mu Mulago mu kicweka kino kandi n'abandi kandi na daktari akwetebwa bya Ruhanga otukumanya nti niwe hati akukura ekikaro kino hali alinakuura baitu ekyatugambire nti ekyo kulukubuzibwabuzibwa ali mu kicweka kindi kyonka atali mwejo mmirimo kandi mwekegambirwa nti akabingirwa olwokuba kabalijo omukutu w'amateeka n'ekyo nakyo kigali atugambiye kigali mazima olwokuba akabahaire obusobozi okworayo ekyatakumanya yabaire atakumanya kurungi nikyo ekaize namanya ebiro byona nti nikyo nti ensonga bwe banekyala maiso g'amateeka teba y'okubazaabazaho baitu kandi akukkiriza nti ensonga eno kyakusatu byalugire hano akabazaaho kandi nabyo ne bimugambirwe akukkiriza nti akabikora.
Doctor, please come back. As we wait for us to do these lawyer things, let's go to what you did. So I just confirmed court that the material that you posted also included the colored photos of the deceased as they are represented in this document baptized Defense Exhibit 29A.
Yeah. Yes, my lord.
Okay.
I can confirm that.
Okay.
I posted what was already in public domain.
Okay, you will tell court.
Yeah, yeah.
By public domain, you mean what?
What in an open court?
Oh, okay.
What was already in an open court? Yeah.
The other simple thing I want you to confirm to court is that when you posted it on that social media platform, it generated debate. Did it or did not?
No, my lord.
Was it debated?
It was actually posted because of the previous debates.
Now, I will request you to answer to my question because I'm not interested in your previous debates. Will you tell this court whether after you posted that report with the photos of the deceased person, it generated debate on the platform? Did it or did not?
It generated more debate.
Generated more debate. Doctor, had you engaged in the so-called previous debate on the matter?
That's right, my lord.
When was that previous debate on the subject?
Can I look at my phone and tell you?
Yeah, I think, my lord,
Okay.
that's good. Yeah. And I'm asking when.
Mhm.
But even without the dates, my lord, what I intend to find out, doctor, is you to confirm to court that the previous debates were before you came to testify in this court.
That's not right.
Or it was after?
Immediately after I testified, the debate started.
Okay, so the debate started when you testified.
That's right.
Okay, then that's okay. You can keep this with your phone.
Okay.
As a doctor, are you aware that your professional conduct is governed by laws and the professional codes of ethics?
That's right, my lord.
Is it in your knowledge, doctor, that your professional code of ethics prohibit disclosure of information relating to your subjects, unauthorized disclosure of information relating to your subjects?
That's not right, my lord.
So you, as a doctor, you are at liberty to disclose information of your subjects. Are you or you are not?
That's a misleading question, my lord.
Uh, Let me repeat it
Yeah.
so that I'm sure you have understood. As a doctor, are you at liberty to disclose information relating to your subjects?
Yes, but when it is a matter of court, you can disclose.
As a doctor, you are not at liberty to disclose information about your subject, but it is a matter of course.
Yes, that's right.
To whom do you disclose matters of court?
Uh,
Is it to the court or to the public?
to your colleagues and to court.
Are you in position to guide this court as to the specific court which authorizes you to disclose such matters to your colleagues? You are a senior person.
Yeah. My lord, we don't see.
Are you or you are not?
Again,
For report.
Yes.
Yeah.
Yes. Are you in position? My question: are you in position to guide this court to a specific court that authorizes you to make such disclosure to your colleagues?
No, there's no specific court.
There is no specific court. Doctor, are the provisions, specifically section 30, subsection 5, subsection 3 and 5 of the Health Service Commissions Act, in your knowledge? Are you familiar with the, yes, my lord. My lord, section 33, subsection 3, and section 30, subsection 5. Are those provisions in your,
In my head,
the Health Service Commissions Act?
no, my lord, I don't have them off head.
Okay. Yeah, that's true. But are you bound? Do you feel bound by the provisions of this act? The Health Service Commissions
Yes, my
Act?
lord.
You
Yes,
are
my
bound.
lord. Yes, my lord.
With your indulgence, my lord, I request to read these provisions, and I put the concluding questions to Dr. Nsbu. Dr. Nsbu, section 33, subsection 3. I'm going to read it verbatim. Please listen. It says, subject to subsection 5 and section 30, a health worker shall respect the confidentiality of information relating to patients or clients or his or her family. Such information shall not be disclosed to anyone without the patient's or appropriate guardian's written consent, except where it is required by law.
Very good.
You feel bound by that provision?
Definitely.
I'm also reading you section 30, subsection 5, which was referred to, and says a health worker shall respect the confidentiality of information relating to patients and his or her family. Such information shall not be disclosed to anyone without the patient's or appropriate guardian's consent, except where it is in the best interest of the patient.
I agree with that, my lord.
I want you, in addition, to confirm to this court that you are bound by the Uganda Medical and Dental Practitioners Council Code of Professional Ethics. My lord, it is the Uganda Medical and Dental Practitioners Council Code of Professional Ethics.
That's right, my lord. I'm bound by it.
I am going to read you the provisions of Regulation 6A. Regulation 6 relates to protection of privacy. And under A, you as a practitioner, you are prohibited without the express consent of the patient, or in the case of a minor, with the consent of a patient or guardian, or in the case of a mentally disadvantaged or unconscious, or, and I emphasize, deceased patient. In terms of deceased patient, without the consent of his or her authorized next of kin, you are prohibited from disclosing information of those subjects. Is this something in your knowledge?
Yes, very much.
Doctor, when you published the photographs of a deceased man called Henry Katanga on social media, did you have this required consent from his next of kin? Did you or you did not have?
No, I did not have.
Okay. Will I therefore be sure that your action was of displaying these photographs in that report was unethical, since you did not have that consent?
You are very wrong, my lord. He is very wrong. Because the late was neither my patient or a deceased I worked on. So this, you cannot hold me responsible for that.
My lord, I leave that subject at that, and I'm going to something new. You told this court that when you get your qualifications, you register them with the Uganda Medical and Dental Practitioners Council.
That's right, my lord.
In fact, Qualifications of all licensed medical practitioners like you are published for the entire public on the official website of the Medical and Dental Practitioners Council.
I don't know that.
Are you aware if I wanted to get your records, it's possible to search your particulars on the platform of the council?
My lord, I don't know how accurate those records are.
Do you doubt the accuracy of your regulator, the information provided to the public by your regulator?
I have no reason to doubt it.
You have no reason to doubt it. I want to search for your record, and my requirement is that you confirm to court whether that is a true reflection of your standing in terms of your professional qualifications.
That's right.
My lord, may I request the court assistance to go on the public record and display it in court?
My lord. The witness was asked, do you give those qualifications to the Uganda Dental Medical? Then he asked him, are you aware that they put them on their website? And his answer was, I don't know how accurate those records are. Now what we are doing is that we are putting out those records that the witness has already said, I don't know how accurate they are. And I have no doubt, I have no reason to doubt them. I say, I don't know how accurate those records are. And now we are putting them out for him to confirm that they are accurate or not, when he has already said he doesn't know how accurate. Can we listen?
They are public records
Yes, my
of the website.
Yes, ma'am.
His regulator.
Yes, ma'am.
And the witness is here.
Yes,
He has said he cannot know whether they are accurate, but he has no reason to doubt.
yes.
Yeah, anyone can go to the website.
Please go to the Google search. You type in UMDP, UMDP, Uganda Medical Dental Practitioner. UMDP, yes, space, council, council like city council, not like Mr. Jet. No, the other council with the C. No, C? No. No. L, space, register, yes. S. When you do that, you go and search. Type in, please. If you can follow our instructions without you assigning yourself additional responsibility, do what we are telling you. Register. Have you spaced? Yeah. Type in Onzivua Sylvester. You know the spelling? Mr. Onzivua, how do you spell your name in your records?
ONZ,
You go through.
ONZIVUA.
What? Space? Then the other one?
Sylvester.
You can even search by Onzivua. There are not many Onzivuas in that council. Eh? Add Sylvester. Onzivua, your other name? S.
SYLVESTER. V E S T E R.
Yeah, enter the search. Go down. You are searching in AI. I want, but that we shall still find it, I think. Go down, go down. Okay, click on find health practitioner. Go to, no, go up. UMDPC, no, there. There where the cursor is, not down, down, there. Who's that? Now go to that search engine. Put in on tour, Sylvester. UA. UA. Space. Put Sylvester. Huh?
It's why.
It is SYL. Yes, SY.
Okay, then. Doctor, go ahead and guide him.
SYL VE VESTER. Sylvester Stallone.
Just type in. Other things will come. You never told us you had additional names.
No, no, just to help you with the spelling of Sylvester.
Can, can you remove Sylvester first? Just search on Google. Can you capitalize O? Search. Maybe you close and begin again. I wrote on my that my laptop is clear. Or you use actually, Mr. Antende, start with Sylvester. Start with Sylvester on the board. If he has no data, my lord, we shall use the laptop. Wanted the platform for all of us to follow. Can you, are you able to connect this laptop to your screen? So that we use the laptop? Dawood, if you fail, please, we can use the laptop. Just advise us if your thing is. My lord, can we use the laptop? Can this connect?
When it projects.
Yeah. If, the other alternative, my lord, would be for to invite the witness, my lord, to come, and he does it instead of through any computer, and he tells court what he sees by himself. Is it okay so that we save on the time?
Yeah, my lord, I just would like to understand what council is trying to search for.
You will not understand these things. This is just
No.
what we are doing.
Then such
Yeah.
Then you do it.
Actually, you can even use your phone if you like.
My lord, when we register, we are given a practicing certificate. We have a registration certificate. Those are the most important things. If council wants them, I can avail them, my lord.
Let's use what is here now. The public record.
Have your practicing certificate with you here.
I didn't come with it here.
Yeah, that's why we are using what I'm trying to do. Okay, stay here, yes. You are better than me. Ah, there you go. Doctor, is that you?
Yeah, that's me. That's the photo I supplied.
And and this is your regulator.
That's right.
Look at your qualifications. They reflect your true academic standing as filed by the regulator. Take your time. Yes, my
One
lord.
of the assessors.
Oh,
Yes, that is.
yeah.
My qualifications are, those are okay.
They are good.
Yes, those are the ones.
But let's wait for the assessor. So that yeah, by the way.
is my beautiful wife. The other one is my beautiful wife. Yes, you can see there.
Twage tutegereze nti yandika ekimu agateekawo lutimbe olwaliwo n'abadaktari abandi abakola nabo kitongole ekipya koramu kandi kino kikaleetaho okuyimusanisa kw'ebiteekerezo baitu bakasamu babaire bayimusanisa ebiteekerezo baitu byakuteiremu byayongera kuleeta okuyimusanisa okundi kandi kino katandika nakyamara kuba obujulizi hano kyakujozi kyakusatu akimanyire kurungi nti uwepo mtendeki mkadaktari mtendeki aina ekitongole rundi baina ekitongole kyobusobozi kibakura kandi hariho ebintu ebimu ebitaikirizibwa kukolebwa n'abantu abandi bona baitu okuyaho akusanga wakiba kiri kintu ekiri kyamateeka bakusobola baikirizibwa nti okusobola kugambiraho bagenzi bawe rundi okugambira olukala lw'amateeka baitu kandi kusaho olukala lw'amateeka lwonna olwikiriza olwamanyire olwokumwikiriza kukola ekintu nkekyakozire obuteeka mu kitabu ekyohereza obusobozi ebulungi ekibakuura abadaktari kuteeka ka 33 akasatu rundi akasatu akateeka kake namba 5 abimanyire baitu tabimanyire mu mutwe baitu kandi nakimanya nti nibimukwataho kandi nibyo bimukugira rundi nibyo bimuhereza ekyokukola kandi okumugamba nti kino kyakozere nti akatwe ekiragiro agambire nti tikirinyuko ekyo kiri aho kuba omugenzi Henry atabe mulwaire we rundi atabe omuntu weena obu byakozereho kandi nti obatunga obukozesebwa kuwona bakuhandikisa omu kitongole ekyo ekibakuuraho nk'abajanjabi kandi nawe ebihandiiko bye byona ikaina bihandikisa kandi hano hari turi kukolekebwa obutendeki bwe alutimbe olukooto
So Dr. Nsgua, first read your qualifications for the record. We can see them, but you have to be on record. My Lord, the assessor is back.
My Lord, my qualifications are MBCHB, meaning this is in Latin, but Bachelor of Medicine and Bachelor of Surgery of Makerere University, 1992. M.Med means Master of Medicine of Pathology in 2003. The other one is Diploma in Forensic Pathology, the postgraduate diploma in Forensic Pathology from the Colleges of Medicine of South Africa in 2005.
So, which of these three makes you a forensic pathologist?
The last one, my Lord.
postgraduate diploma in forensic
First-
pathology.
That's right, my lord.
Okay. And your regulator can only include these qualifications on your professional public portal because you registered them with them. We registered the documents with them.
That's right, my lord.
Does your regulator verify before publishing? Verify the authenticity of your documents before publishing them?
I am not the regulator, my lord. I don't know.
Okay. Okay, I want to sample maybe one more example so that we can compare you and what other results by other people. You want to volunteer who we should sample? Okay, let's sample your friend William Male Mutumba.
That's right.
Okay. Type in William Male. Search. Check it out. Is that the William Male Mutumba that you were talking about?
That's right, my lord.
The one who did the postmortem report that you reviewed?
That's right, my lord.
Okay. Are you in position to read the qualifications that are displayed that he possesses?
That's right, my lord.
Okay. What does he possess?
Bachelor of Medicine and Bachelor of Surgery of Makerere University, 1984. Master of Medicine Pathology of Makerere University of 2005.
You go through Master of Medicine
In Pathology
Yes.
of Makerere University, 2005.
Yes.
Then Diploma Forensic Pathology, College of Medicine of College of Medicine
Is it,
of South Africa.
which year?
I can't see well from here.
It's clear, even the blind can see. Yeah.
Our eyes vary.
Okay.
But can I move closer and
Sure,
see?
sure.
Yeah.
But it is expanded for you for avoidance of doubt.
Oh, okay.
2012. Okay. Thank you. So, doctor, from an academic point of view, do you possess any superior qualifications than that man called Male Mutumba Williams?
No, my lord.
In fact, the professional qualification for being a pathologist, you are both trained from the same college.
That's right, my lord.
I just wanted to correct the impression that you had, I believe, inadvertently caused, referring to that gentleman as the less of a pathologist.
That's not right, my lord.
In fact, Dr. Nzvua, in terms of seniority, Dr. Male is more senior to you. He started practicing medicine way before you became a student of medicine. He qualified in 1984. You qualified in 1992.
That's right.
I now want to do one more thing, Dr. Nzvua. Are you familiar with, again, let me save on the time. I want to read you Regulation 22 of your ethical code of conduct. My Lord, I am in the Uganda Medical Dental Practitioners Council Code of Professional Conduct. Regulation 22, Dr. Nzvua, this is what it says. It deals with professional reputation of colleagues. I believe you know it, you knew it even before coming to this code.
That's right, my lord.
A practitioner shall not unjustifiably cast doubt on the probity or professional reputation or skills of another practitioner. Practitioner shall not unjustifiably cast doubt on the probity or professional reputation or skills of another practitioner. You were in this court last Wednesday, Doctor, and you imputed the professional standing of that senior gentleman. Having brought Regulation 22 to your attention, do you regret your imputation?
Absolutely not, my lord.
I wrote again, I will leave that point at that and move to another subject. May I pray that yes, thank you, sir. We are done. We can go back to Zoom.
My Lord, we will need this laptop.
My Lord, the laptop is available if Mr. Kavega can't afford one.
This particular is not a question, my Lord, it's not a question of affordability. This is the one which council has used.
My Lord,
I don't want to use mine because that hasn't been. Yes.
I know Mr. Kavega is not may not be IT compliant, but what has been displayed there is not a laptop. It is information from a website. But the laptop is available, my Lord.
My Lord, you used the hot one, and it failed to give us this.
We shall use this one.
Yes,
Don't worry,
so
Mr. Kavega. Yes. Yes. My Lord, I pray for Exhibit 128 to be passed over to Dr. Nzvua. Doctor, that was your very first report that you issued, your first opinion that you issued in this exercise. Can you read to court the first sentence in paragraph 1?
I acknowledge.
No. Paragraph number 1.
Supposed to be the first sentence.
In paragraph numbered 1.
Oh.
Yes. Up to the word and, then you end there.
Okay. The body of the late Henry Katanga was brought to the Kampala capital city mortuary in a private vehicle.
Proceed up to officers.
And not a police vehicle or accompanied by investigating officers.
And end there. Okay, maybe you complete the sentence. Sorry.
As should have been the case.
My lord, I pray that the postmortem report is passed over to the witness. We could use the one he used, my lord, which is DE 22. DE 22. Let's use the one that he worked with. Dr. Nzvua, please take court to the source of this information in the report that you possessed at the time of making this report. Specifically, information pointing to the body having been relayed to the mortuary, not accompanied by the investigating police officers.
My lord.
Is it there?
There is no investigating officer noted here to have accompanied the body, my lord. Okay.
So will I be correct to say that this is extraneous information that you got from other sources, not the report that was before you for review?
No, my lord.
What is the source of this information that you put in your report?
My lord, this post-mortem report.
Okay, take court where you got that information in the post-mortem report. Forget about the vehicle. Just go to the fact that the body was delivered to the mortuary, not accompanied by any police investigating officers, as should have been the case.
My lord, it should have been recorded here which police officer accompanied the body.
It should
have been recorded.
Should have been recorded. So because it was not recorded, you confirmed it as a fact that it was not the case. Is that what you want to tell this court?
No, my lord.
So what informed your conclusion? You are making a statement of fact in your own report. What informed your mind to arrive at this statement of fact?
The post-mortem report.
Where?
My lord, there is no name of a police officer accompanying this body. That's what
Exactly.
I've-
So please kindly understand my question.
Yes.
So because there is no name of a police officer who accompanied the body, that is what informed your conclusion
That's
that
right.
there was no police officer that accompanied it.
That's right, my lord.
Well, just to put your notice that this court already has evidence of which police officer accompanied the body. Do you regret that you made an incorrect statement of fact as a professional?
From the post-mortem report, I could not have done otherwise, my lord.
Does the postmortem report indicate that no police officer accompanied the body?
He has answered that.
He has not, my lord.
Because he said that because the post-mortem report did not indicate which police officers accompanied the body, I made the conclusion that no police officer accompanied the body.
Will I be correct, Dr. Nzbua, to say that simply because the postmortem report didn't mention that fact, you assumed that there was no police officer?
My lord, I could not assume otherwise.
So you assumed?
I
That's
could not
what-
assume otherwise.
Okay. That is still fair. And for clarity of mind, Dr. Nvua, which this court will be correct to conclude that your report also contains assumptions.
My lord, maybe let's be specific on which assumptions.
Okay, you will tell court
Yeah.
whether which specific assumptions, but
Okay.
does it contain any assumptions
Not any that I'm aware of.
apart from?
Not any that I am aware of.
I want you to go to paragraph 2 of your first report.
Oh, I've already given it.
Paragraph.
I've already handed it over.
I don't have it.
Okay.
Please return please, Lydia. Paragraph 2. Read it to court.
The post-mortem examination was carried out and report signed by two pathologists, Dr. Male Mutumba and Dr. Ambayo Richard, who are well known to me.
How did you conclude that paragraph? Read the last
I
sentence.
know for a fact that the two ex-pathologists have no specialized qualifications in forensic pathology.
Read it again. You know it for a fact.
I know for a fact that the two pathologists have no specialized qualifications in forensic pathology.
Doctor, with what you have just informed this court in respect of Dr. William Mutumba, do you still maintain that this, your conclusion in respect of Dr. Mutumba, is correct?
Yeah, to the best of my knowledge, yes.
Just to remind you, a few minutes ago, you told this court you hold no superior qualification than those of Dr. Mutumba. Do you still hold this view at this moment in time?
Of course, with respect to forensic pathology, I still have question marks, my lord.
May I know under what authority you have question marks? You have question marks as who?
My lord, I told this court that I coordinated the training. Yes, as a coordinator of that particular course that Male Mutumba went to attend in South Africa.
Coordinated the course on
That forensic pathology. That Male Mutumba attended in South Africa. Of that group that went, 2 pathologists did not qualify. That time, two of the pathologists that we sent to South Africa did not qualify.
Okay, so Dr. Mvua, good enough. By any chance, were you any of the instructors of that course?
Yes.
Were you or you were not?
I was.
In South Africa?
No, they started here.
No. That qualification you read to court is attained in the College of Medicine, South Africa.
That's right.
Yeah. Maybe you are mistaken. I'm talking about what you read. He started from the same college that you went to in South Africa. Were you any of the instructors in that university?
My lord.
Were you or you were not?
Yes.
You were one of the
instructors
in that university.
I think you don't understand, my lord. No, it is colleges.
I can assure you that
no,
I do.
No. Maybe I need to clarify.
No, maybe
it is
colleges. Clear to you.
Colleges of Medicines of South Africa. It's not one college. Colleges of Medicines of South Africa.
That's right.
Yes.
That's right, doctor. So thank you for the clarification. Were you any of the instructors or teachers or professors in that university?
Yes, my lord.
So you taught this gentleman in that university and he failed?
The teaching, yes, he failed.
This court wants to be very clear with you, Dr. Nzboa. Did you teach? Yes, please.
Yeah.
Did you teach this
Yes.
man in that university?
My Lord, for clarity,
In that college? My question
Yes.
is clear, Dr. Nvua, please.
that's right. I would like to clarify.
Did you teach him in that colleges of medicine in South Africa? This is simple, please.
Yeah. My Lord, can I say how this course was
Please.
conducted?
My Lord, you asked
Please,
Yes.
please.
I need to clarify, my Lord. Yes.
Did you teach this
Yes.
man in that college in South Africa?
Maybe the witness needs to give us a bit of a background about this.
Yes.
My Lord,
Yes.
my Lord, I don't require a background in this question.
But my Lord, the court
I am
has
asking.
asked.
Yes, the court will, but my question cannot be modified by Mr. Tumweba.
No, the court has.
No, my Lord, I won't allow that. I'm sorry. I am not allowing for yes.
Much obliged, my Lord.
Let him write. He has his time. Yes.
I wanted to know because you kept asking and saying.
My Lord,
So
we
I
shall.
wanted to know how
Yes.
it works so that we understand.
Yes.
You need to write the respect in which he was aware of how Dr. Mutumba performed.
Yes.
I shall oblige the court, my Lord.
My Lord, my land friend, my Lord,
Let us hear.
my Lord, this is a question of procedure. We retreated to our chambers the other day, and my land friend should courteously do what we agreed in the chambers. Yes,
So what value are you adding to what we
it's
have?
actually that.
You actually
that.
No, my
you
Lord,
are trading court.
That's what you say in your book.
Defense and prosecution, let Dr. Ojibwa give a bit of the clarification.
Please.
How
Yes.
My
Yeah.
Lord, I am most obliged. These people won't answer for Dr. Nzua. Dr. Nzua, please answer what the court is requiring.
Yes.
Mr. Tumweba.
My Lord, I designed this program for training Ugandan doctors. The colleges of medicine of South Africa allowed us here in Makerere to do the initial teaching, and the students would only go to South Africa to do the practical part of the exams. The first part they even did here in Uganda. So here I was their supervisor and their teacher. This was in collaboration with the colleges of medicine. They made, sorry.
So you designed the course.
I designed the
It was
course,
in two parts. Part of the training was in Uganda.
right,
The other part was
in South Africa. Yes.
Run by Makerere University.
Yes. We were a satellite college.
My Lord,
And,
do I
and
proceed?
and my Lord, that's how I ended up teaching them. And when the results came out, they were put on the website of the colleges of medicine of South Africa. That's how I knew Male Mutumba did not qualify.
And which year was this?
This was in, I think, 2012,
When did you get yours?
2005. And my Lord, with respect to that, we can go to the colleges of medicine of South Africa. The results are still there on the web. We can show it here, whether he qualified or not.
Proceed, Mr. Moses.
Now, Dr. Nvua, just a simple thing. By the way, even what you requested is good, and don't mind. We will afford you that opportunity.
Okay.
This court would be interested in knowing, were you part of the decision makers in the College of Medicine in South Africa as to who to qualify and who not to qualify, or you just had, or you were told that your colleague did not qualify?
On the website where the results are displayed, his name was not there.
You just saw it on the website.
That's right.
Again, because you never saw his name on the website then, that is what led you to assume that he never qualified, correct?
That's right, my lord.
But I just want you to confirm that you are not part of the awarding authority of these qualifications in that college in South Africa.
No, my lord, I am not.
So just to remind you that that is the second assumption that you made in this report. We are now going to the third one. Read the third paragraph.
There was a fundamental error in the identification of the entry and exit gunshot wounds.
Proceed.
Gunshot entry and exit wounds on the skull are identified by the beveling effect of the bullet on the skull. This was not mentioned in the report and probably not looked for and documented.
Now, your closing remarks in this paragraph, you are talking about the probability of your colleagues not looking for it or not documenting it. Just to confirm to court that this is not a finding backed by evidence, but it is an assumption.
This finding is backed by the postmortem report.
What in the postmortem report backs this finding? Go straight.
Beveling was not mentioned.
Again, because beveling is not mentioned in the postmortem report, you assumed that it was not looked for by your professional colleagues who authored the report, correct?
Such an important
Correct
thing.
or not?
Such an important thing.
Is it the reason why you assumed? Please, doctor.
Yes.
Okay. Please, let's move.
Yeah. Okay.
We don't want to keep you here for so long. Want to move very fast, you go. So that is the third assumption in your report. We are going to another one. Please, doctor, go to the fourth paragraph.
There is no doubt. There is no.
That
Oh.
is number 5. You go to number 4.
Oh. The entry and exit wounds should have been identified at the post-mortem examination and then swabbed for gunshot residue. There is no record of this having been done.
Doctor, I carried your record here, but without us wasting a lot of court's time, this is the first case involving gunshot injuries to the head that you appear to testify in the High Court. Correct?
That's not right, my lord.
How many cases of gunshot to the head have you ever testified in?
My lord, the Godi case, I went and reflected.
I'm looking for a number, doctor. Don't volunteer too much. Answer my question.
I don't know how many.
So the answer is you have testified in several cases.
In several cases, yes.
Gunshot injury,
Yes.
the head.
The Godi one, yes, there was one to the head.
You want to, Godi is a public record. You want to go on record that Godi case was gunshot to the head? It's a public record.
Yeah. My lord.
Do you want to go on record?
Yeah,
that
that's
the Godi
true.
case was gunshot injury to the head?
There were 2 gunshot wounds. There were 2.
Was one of them to the head?
Right.
I'm not conceding that it is correct, but it is on record. Okay?
That's
so
right,
I don't
my
want
lord.
to bother much, my lord.
Okay.
Godi case is a public. We will traverse it. So other than that, do you remember any other in your entire career?
My lord, I need to think backwards.
So you can't remember any other.
I have done too many postmortems.
Dr. Nzbua, do you just remember on Thursday you told this court that you only had an opportunity to testify once in the court martial and not in the High Court? Is that something that is fresh in your mind?
My lord, I said I don't remember. My words here were clear. I don't remember. When I went back, I reflected.
You don't remember?
Yeah.
What?
On Wednesday,
You said you don't remember.
I didn't remember other gunshot injuries that are handled in High Court.
Okay.
But I remember one had handled in the military tribunal. Yes.
So when you went back, doctor, you reflected and you remembered only the Godi case.
That's right.
Okay. So that your finding in paragraph 4, was it therefore a finding of scientific fact, or it was an assumed fact due to absence of information in the postmortem report?
My lord, it was due to absence of
Was
information.
assumed due to absence.
Of information, yes.
I have lost count, but I am recollecting that that is the fifth assumption that you are making.
They are not assumptions, my lord.
Are they facts?
They are facts, my lord.
Now, read to court paragraph 5.
My lord, in paragraph 5, I wrote, there is no doubt
There is no doubt
that the gunshot entry wound was through the right ear, as demonstrated by the powder blackening, as well as the blast effect of the gunshot that caused extensive lacerations of the outer aspects of the right ear.
Doctor, you will agree with me that any person would only make this conclusion that you're making either by looking at the physical body or by looking at the photograph.
That's right, my lord.
I just want to remind you, my good doctor, that by the 3rd of July 2024, when you wrote this report, you had no idea about the photographs. They were given to you a year later by your own testimony. So, that being the case, what was the source of information in this particular paragraph?
My lord, at this point, there were black and white photographs that had been, I think, supplied or something like that.
Please, I advise you not to think. No. By thinking, not that he should not use his head. But this is not, my lord, this is not a speculative process. That's what I mean. Please, doctor, you are a witness. You are a witness. Please, Mr. Jet, let's not go there, please.
When the witness supplies that answer, even when you are uncomfortable, you accept it.
I have accepted it, so I am. Doctor, I am advising you kindly that you are a witness of fact in this court.
That's right.
Not assumptions, not guesswork. So that's why I'm saying, don't think. If you know, you know. If you don't know, tell this court. So let's now proceed from where you ended. So by this time, there were black and white photographs. Is that your position?
I don't remember. I must say, I don't remember exactly
Where you got this information?
What informed me at this time of this.
You don't remember. So, my lord, do we proceed? Do we? So you are aware, doctor, that every scientific conclusion must have a proper basis.
That's right. That's right.
But you do not remember the basis for which you made the conclusion in paragraph 5.
Yeah, the facts which informed this.
The facts.
Yeah.
But do you remember having any black and white photographs?
I don't remember I don't remember really whether I had them or I didn't have them.
Do you remember whether you had them at all?
That's what I'm saying. I can't remember.
You can't remember. Doctor, we were here on Wednesday and we advised you to carry your 2 bulk files that you were given, because those will actually enable you to recollect. Did you carry them?
Yes, my lord, I have them.
You have them.
Yes.
Do you think they can help you to remember whether you had or you did not have? Because that is your engine for this report.
Yeah. My lord, at that time, I had
now,
not.
now, my lord. Now.
They cannot help me.
They can't help.
No, because I made this report before.
Before you got the file?
I got the file, yes.
Oh, okay. That's even better.
Yeah.
Again, I am moving on.
Yeah.
Doctor, you realize that we are moving from assumptions to completely no basis. So I want you now to go to your next paragraph. Paragraph 6.
My lord?
Read it.
Yeah. It is extremely rare for a bullet that has been randomly fired through the skull to exit precisely through the ear. The converse.
Just read it again.
Yeah.
Doctor.
It is extremely rare for a bullet that has randomly been fired through the skull to exit precisely through the ear. The converse, however, is very common.
So, where did you get the information that the bullet that you were dealing with was randomly fired?
My lord, this is common sense.
You used common sense. Okay. So you will agree with me that the basis for your conclusions in this paragraph is not based on a scientific evidence, but common sense.
My lord, science is based on common sense.
And in this case, you used common sense. Yes?
Right, my lord.
I'm putting it to you, doctor, that by the time PAA contacted you to generate this first report, you were briefed of a case theory that people were fighting in a room and a bullet accidentally got discharged. And you were working through that theory at the time.
My lord, that is speculation. We object to that kind of thing. They are inviting the witness to speculate and the committee is speculating.
My lord, I'm putting a statement of fact.
Confirm whether or not he had been given a story. All the
That
witness
theory.
has to
Yeah, that theory was not there given to me.
Okay. So, doctor, at what stage? Let me wait for court to. Now, you agree with us that suicide is targeted shooting. Somebody decides that they should shoot themselves. So, at what stage did this bullet turn from being a random bullet to a suicide bullet, which is a targeted shooting? At what stage did you change your mind?
My lord, I have never said this was a random bullet. I have never said this particular bullet was a random bullet.
I am moving to the next paragraph.
Okay. Yeah.
The rest is for Ras and Paul.
Okay.
Please read paragraph 7.
In paragraph 7, should the exit wound have been through the right ear, then brain matter and bone fragments would have been evident through the wound. But these were significantly absent in the pictures
Okay.
and not mentioned in the postmortem report.
My Lord, are we there? So now, Mr. Dr. Nzvoa.
Maybe a bit of learning from court.
Mm.
If a bullet comes through the ear, we expect brain matter and bone fragments
That's right, my
because
lord.
of where the brain is situated.
That's right, my lord.
We will come to that even more. But for now, Dr. Nzvoa, you see, at this stage, you have to tell a court who had briefed you about the pictures at this time of writing the report. You had none at the time, but you are referring to them in this report. Where had you picked this information on pictures?
My lord, as I said, I don't remember at that time where I got that information.
Just to be sure that you are clear, court.
Absolutely, my lord.
This report here
Right?
was made for you, and your only job was to append your signature so that your credentials can be used to propel a specific defense theory. You never made this report, Dr. Nzvoa, because if you had done so, you would know exactly where you got the information contained here.
I object very strongly. I have my laptop here. The report is here, made by me on my laptop.
Is it your testimony, therefore, doctor? that even though you did not have pictures at that time, there was the possibility of you imagining them and making reference to them.
My Lord, that is not true.
What is not true?
That I imagined these pictures in my head.
Did they exist before you when you are making this report?
My answer is simple. I do not remember the source where I got these pictures at that time.
Doctor, let this court rely on your expertise for this fact. If there is evidence presented before you as a pathologist that a body was cleaned prior to postmortem examination, would you still expect to find things like blood, like brain matter on it?
My Lord, that depends on
If
how
there is
thoroughly
evidence, if there is evidence.
that the body was thoroughly cleaned.
I don't know.
Precisely, that's my
I've
answer.
just told you about cleaning.
Yeah. Yeah.
Depends on how thoroughly it was.
The body was cleaned, yes.
So if it was cleaned very thoroughly, you'd expect no brain.
You would not expect. But if it was not cleaned thoroughly,
I'm taking you to paragraph 9. I will traverse 8 elsewhere. Please read 8. 9 rather.
my Lord,
Yes.
there is no independent forensic evidence described or otherwise to confirm that the wound on the left temporal area was a close contact wound.
Yes.
The authors of the postmortem report should elaborate on this.
I want you now to read your concluding paragraph on page 3. What did you conclude as to whether the gunshot injury was close, near, or distant?
My Lord, should I read the
Please.
whole conclusion?
No. The second sentence. The court has the report.
Oh, okay. The gunshot was also a close contact considering the blackening of the right ear.
Okay. So the reason you concluded it was close contact was because of what you call blackening of the right ear.
That's right, my lord.
Okay.
And the lacerations, my lord.
Now, Dr. Nzuvua, I just want to be clear. Do you believe that a bullet entered Henry Katanga's head?
That's right, my lord.
You believe that?
That's right, my lord.
And you believe that it exited?
That's right, my lord.
Read paragraph 11.
The bullet must have moved from right to left, upwards with a slight deviation backwards.
Okay. Hold it there. By use of the word must, doctor, this is confirmatory, done and dusted.
Right.
So by application of this word, you have no room in your mind of alternative possibilities.
Absolutely not, my lord.
Could you explain a bit what slight deviation backwards means?
My lord, in the slides that I showed here, to me, the entry wound was to the right, in the right ear. But the exit wound was above the left ear and behind it, above and behind. So this means that it moved from right to left with a slight turning at an angle, not a straight angle, not straight line, but at a slight turning backwards. So that's what I mean by slight deviation.
Now, confirm you never physically dealt with this body.
No, I did not.
You only dealt with the pictures, the photographs.
The photographs and the postmortem report.
Doctor, since you never dealt with the physical body, how did you determine those slight deviations backwards?
My lord, the measurements
You,
in the
you relied on which measurements?
the measurements in the postmortem report.
You relied on the measurements in the postmortem report.
That's right.
Okay. Do you believe in the measurements, in the authenticity of the measurements in the postmortem report?
I do.
They are accurate.
I do. Except, of
Are
course,
they accurate?
some are, some are not.
How did you determine those that are accurate from those that are not?
My lord, when a whole ear is measured and said to be a wound, that is inaccurate. But when a wound is pointed at the back of the head with the measurements, you can see that these are authentic. The positions that were described in the postmortem report, my lord.
Doctor, where is the source of information that the whole ear was measured?
My lord, in the postmortem report here, Uh, a wound was described as 3 by 5, 5 by 3 centimeters. This was an absurd wound. 3 by 5 centimeters as an exit wound. Actually, I got alarmed when I read this.
I don't think that it will be surprising for you to be alarmed. But my question, so that you don't alarm us, my question is different. Where is the information that the whole ear was measured by anyone? Is it contained anywhere?
Yes.
Can you point to quote that particular part where you get the information that the entire ear was measured by anyone?
I demonstrated it in my
Is it there
present.
or it is not, Dr. Mvua?
It is there where they
Please
put
point
the
to
ruler.
quote, read it to court.
Not in this postmortem report, my lord.
Okay. So where did you get it?
The pictures, my lord, which you sent, my lord.
So you looked at the pictures and concluded that the people who dealt with the pictures were measuring the entire ear. Is that what you want this court to believe?
That's right.
Okay. Now, doctor, this is the final section of this, your first report. We had to traverse it so that court knows where you came from and how you dived into the second one. By the time you make this report, you are fully retired and no longer a serving pathologist of Mulago Hospital. Just for emphasis, isn't it? That doesn't require a lot of thinking. It should be either fact or not.
My lord, it's a fact. When I signed this report,
I've not even
yes.
come to signing. Please, you were fully retired. That's all I want.
That's right.
Doctor, when you retired, did you hand over the stamp of Mulago Hospital that you used as a consultant pathologist? Or you retained it?
My lord, I have a personal stamp which I retained.
This court knows what is personal and what is not. I am asking about your official stamp which you used as a consulting pathologist, Mulago Hospital. Did you return it to your employer?
I was never given a stamp. I could not return what I was never given.
So you made yours.
I have always had my personal stamp. I have always had my personal.
Doctor, please confirm that you stamped this report in the capacity of Dr. Sylvester Nzivua, I'm sorry.
Yeah, no, it's okay, my lord. Yeah. It's okay.
A consultant pathologist, care of Mulago Hospital.
That's right, my lord.
By the time you are authoring this report, did you have any legal connection with Mulago Hospital?
Yes, my lord.
Tell this court your connection with Mulago upon your retirement?
Yes, my lord. I'm a retired civil servant of Mulago Hospital. That's a legal position.
So that keeps you in permanent relationship with Mulago.
That's right, my lord.
I unfortunately putting it to you that, Doctor, you are, for all intents and purposes, holding out, and that your representation of your good self as having an address of Mulago Hospital, the institution that you had left long before the report, amounts to professional misrepresentation.
That's not right, my lord.
Lord, can some interpretation be done before we progress? You can be returning those.
Okay.
I'll return them to you.
Ebikolo halimu okutendekebwa manimo okukira daktari agambirwaho daktari Male Mutumba otugambirwe nti byona byakozere taine kiyahikire nabwekyo takwekera kuba ali omu ali abadaktari abakora mu kicweka ekyo kandi obukicweka bwona obukunkwata naho bwenko ng'omuheereza w'obukiikaro ebyo bwona kumanya kandi talina bintu byona takubuulira nti alina ekibi byona byakozere okuba n'agambaho omugenzi we mulingo ogwo. Ekihandiiko ekyabandize kikwoleka nti omubiri gwa Henry Katanga gukaletwa hairwaro gukaletwa omulyakuuro ly'emitumbi ery'erubuga Kampala mu motoka etambala ya poliisi kandi batasendekeziibwe poliisi ekintu ekyarozere kyabaire nigicwa amateeka kandi ataboho n'omusirikale weena akaba asendekerezeho. Bino byona bikaba nibiruga nikituka nti akaba ataliyo atabirole baitu kandi ekihandiiko ekya highway okuruga mu batonganiriza abamuhaire omulimu kikaba nikoleka nti bino byona bikakolebwe kandi ekintu ekitabaire kirungi. Kandi okugumya nti omukulu ono Male atatunge okutendeka okwokumumara okumwikiza okuba daktari owakweyeta uwe wenyini akabaha kakurato akabaire nikakulira abaali nibasoma obusumi obwo kandi nuwe yahandikire okusaba okwabaletirize okuweereza abadaktari babiri bagende kusoma baitu obu basomere byona ebyarugiremu babihandiika olutimbe olukoto muno olwensi yoona olukoleka ebintu ebikoleibwe kandi obwebyo ebyakozere bitabeho kalutimbe ekikoleka nti gali mazima ataika ekintu kyona kandi tasemereire kuba ali daktari okukebera okwabafu kandi hakabaho ekintu ekibibona ekyakozerwe kandi ekyayogebwa omu kihandiiko ekyamuhaire nti etateirweho amaani ekikoleka nti ali esasi lyatahiire
bakubaire bakirozere kandi bakihireho bakire ebikukwataho kandi bikebeirwe niko basobole kuhereza ebintu ebiri byamazima. Omukulu w'obujulizi aizenaho obujulizi emisango nyingi eyatakwijuka eyebihoye byahamutwe baitu omukulu nogwakwijuka kandi neseku yamanyire muno nigwo omusango ogwa godi baitu atale yotaina endi yakwijuka baitu kyamanyire nti ebaire nyingi muno guli nigwo guno gwonka lundi ogwabairemu kandi nkikigumibwa kigumiza kimo nti eisasi likaraba omukono gw'omulyo lyaturukira omukono gw'omuntu habwokuba saidi habwokuba harubajuru obulyo hakaba hariho okwiragura muno okusinga ahandi kandi kuli obulwadde bw'obumoso hariho okutagurwa kw'omubiri ekikoleka nti niho eisasi lyaturukire katukana okuba nti manya nti abwire buno akaba takurora akisisani ebyomutumi omugenzi baitu bino byona bikaba biri omu kihandiiko ekyahairwe baitu amazima gali nti ebya sayansi biba oba oyina kuba oyina hali okusigikira oyina obwakristo bw'amaanyi kuka amalira ebyokozere kyonka eno hano akaba tayina obwakaiso buno nk'obwebisisani baitu kandi twetegereze nti kandi nebyasayansi nabyo bikorera hamu n'okumanya so omukumanya kwe akumanya ntiiko kye akakikora amalizire emirimo ye mulago baitu kandi ati akozesa obwokulorwaho obwirwara eryo nkakukorayo kandi kugambire nti uwe akyaina enkoragana ey'amateeka n'ekicooka kino baitu kandi kikuru muno linkairwaro nitamuheka okulorwaho koona kyonka akakekoora we wenka kandi
Yes.
Is he almost done? We can carry on till
Done with what?
with the cook. I read if it's short we go, but if it's long, we can do lunch break.
pick it up from
Akuguddeko leero omusajja wange. 2:30 exactly.